NACDL is the association of the nation's criminal defense bar.
I've been in the process of a decade of litigation against the state of Colorado Department of Human Services for their failure to move people who are presumed incompetent or have been found incompetent from the jails into either for the Forensic Institute in Colorado or into the community for restoration in a timely manner. So it's been a long road. It's still unresolved. I started doing it in 2008. And now it's a decade later, and we just were in front of federal magistrate Judge Wong, who arguing that once again the state's in breach because people are staying in our jails. Now 6 months they're waiting after they've been found to be incompetent in order to get restoration treatment, and we're waiting for the judge to rule that they should have their asses fined, and they got to take care of these people. Because they're just warehousing these really, really sick people that we all represent in the jail, and it's likely that they're never going to be able to get back in full form to competency because of the way that they're languishing in the jail. So I know how much we all want to be able to help these people, and it's hard because you know that you raise competency and you could end up in a problem like we have in Colorado, which is they're found incompetent, and then they sit in the jail, and they can't proceed with their case, whether it's a misdemeanor case or it's a felony case, and the whole case stalls out, everything's timed out. And so we have questions on whether or not we should really challenge competency. Should we raise competency? I understand there's good faith and there's ethics that are involved, but sometimes there's question marks that I know that we all have. And then, you know, we get to the point where we are in Colorado. Doctors, our state doctors that do the evaluations, tend to find people who think judges are prostitutes as competent. And then we have to challenge them because it's pretty much their way to keep bed space open and to make these easy findings in order to move things along. And we all know that judges pretty much 75, 80% of the time, the studies say, just agree with whatever the state doctor says. And so we need tools to be able to fight these very standardized, very plain and non-formulaic evaluations that we all have read and seen and get sick to your stomach because they just pretty much pass by everything that's relevant in a criminal case, the case that you're defending your client in. And if your client knows that the judge is the person that sits up at the bench and you're the defense lawyer and the prosecutor is the one that's trying to send them to prison, that they're competent. But we all know that there's more than that. And the studies and the research and the guidelines that are both in the American Bar Association guidelines and psychiatric and psychological guidelines say differently. So the first thing, cross-exam basics. This is for anybody that you're cross-examining, especially an expert. And by the way, these slides I've given to Gerald so that you could also add them to the materials that I've used. So when you cross-examine anybody, but an expert, you want to know what they did, what's the case law they were guided by, how did that expert know how to do that, ask those questions or use that forensic tool that they used? How can we tell you did it? How do we know you really did it? What went into your assessment? Is there a verifiable result? Can you show us that result? How did you verify that? What questions did you get into to make sure that that person's competent? And how did you draw your inferences in order to make that result? So that's kind of the big picture. That's the big picture. But now we're going to kind of do a little bit more surgery when it comes to that and get inside of it. The first thing, which is pretty obvious, is that competency constitutional law started from the Dusky case. It's a case that it's about a paragraph long. It's not much longer. And all it guides you is 2 specific criteria, whether or not somebody is competent or not. That's it. Whether the defendant has a sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether a defendant has a rational and factual understanding of the proceedings against him. That's pretty much the standard across the country, whether you're in federal court or state court. There's a few little changes, tweaks in Colorado that we have, but that's pretty much the general constitutional standard. If an expert doesn't know that, you go after that expert. That expert should know the law. This is a legal determination that is made, whether or not your client is competent or not. They use a clinical evaluation to make that legal determination, but it's a legal determination. Your experts should know all the laws that relate to competency, period, end of story. If they don't, they're on the stand and you're asking them about the case law that we're going to kind of get through a little bit, and they don't know those cases, you are going to have an automatic challenge to the fact that this individual is not qualified to be able to do an evaluation. So using that definition, now we got to break it down. And how do we break it down with an expert? So the main concepts: does your client understand? Can your client assist you, instruct, give you evidence? Can your client do those things? Those are the big picture ideas inside of what the Dusky standard requires. So does your client have the capacity to make decisions? That's pretty simple. Is the expert asking those questions of your client? Does your client have knowledge, understanding, and appreciation of the charges? Does your client even understand what the defenses could be, what the facts that are important for the crime that they're alleged to have committed are? Is your client able to assist you? And that is when it comes to decision making and assisting your lawyer. This is not about, your client has to be autonomous. Your client can't be looking around what my mom thinks I should say, what my dad thinks I should do, what my lawyer thinks I should do. Your client must be autonomous, must be able to make his or her own decisions and be able to assist you. And the only person that understands that is you. The lawyer is the only one that can help the evaluator and tell the evaluator, look, I can't even explain the sentencing regime to my client. He doesn't understand it. She doesn't understand that it doesn't matter that they didn't find a hair in the trash bin when they charged her with trespass. She cannot have communication with me about the most important elements of this case. She doesn't understand that we're going to call witnesses to testify on her behalf to say that she wasn't there. She doesn't understand that that's even a defense. And I'm telling you that, expert, because that's one of the most important criteria whether or not someone is able to assist you, is the defense counsel and what you think. And these cases, the Medina case, the Weeder case, and the ABA criminal justice mental health standards, and the Drope case, all help you be able to attack your expert and ensure that the expert has asked those questions and is written in your expert's report the fact that your client is able to communicate with counsel. Those ABA criminal justice mental health standards, I just reviewed them a couple days ago, and they lay out the most incredible criteria for what your psychologist, the qualifications your psychologist should have, the fact that they should have innate knowledge about the law that they're now going to opine on. They should be able to know the disability. So sometimes they appoint an evaluator that, for example, has no idea about learning disabilities. None. But yet, they're a competency forensic psychologist, but they know nothing about cognitive impairments. The ABA criminal justice mental health standards shoots that down. Shoots that down, and you can use those standards when you're doing a cross-examination. So decision-making is not part of actually the Dusky case, but it's become now more relevant in terms of what your client must be able to do, must be competent to be able to do. And these are kind of the innate rights that your client has, but if your expert is not actually going through these five criteria, then your expert's report is irrelevant and meaningless and not verifiable. Does your client understand the significance of pleading guilty, of whether to testify, whether to waive a jury trial, to cross-examine witnesses and make smaller and strategic decisions? Is your client able to do all of those things? And has the expert actually highlighted that in your expert's report? Because if your expert hasn't, then your expert hasn't done anything to determine whether or not your client's able to make decisions. Because your client has to be able to make those decisions on his or herself. Not looking over and saying, well, my lawyer's going to help and tell me whether I should testify or not. No. The expert should be asking those questions. I provided to you in the materials a very, very long article. It looks like this. It's called Criminal Competencies. It is by far the best resource for all of you to use when you are just trying to get the language correct, when you're trying to draft your cross-examination, when you're trying to do your chapters. It actually goes through the legal and psychological background and studies of the Dusky Standard and of competency. It is really the most premier article that was written by a woman written by a woman by the name of Patricia Zaff, who's a fabulous forensic psychologist. So, how to assist counsel? What is your expert asking your client about? And what is your expert able to talk about when your client, when he or she is on the stand? About whether or not your client's able to assist you. Because an incompetent defendant would be unable to assist counsel in identifying witnesses and deciding on a trial strategy. Did the expert ask questions about what is the trial strategy in your case? What kind of witnesses do you think you might call? I provided to you 2 opinion letters that I drafted for the same case. It's in the second portion of the materials that I provided. So there's a case, the Duhan case, which is mentioned here in the slides. And what that case determines, it's out of Louisiana, is that there is only really one individual that can be able to elucidate whether or not your client's able to assist you. And that's the lawyer. But we can't testify on behalf of our clients, right? So what I've done based on this Duhan case is I've become an expert. So public defenders will hire me to be an expert, and I will go meet with the client. I'll review the records. I'll look at the discovery of the case, and I will then make a legal determination of whether or not I'm able to communicate with the client, and the client could assist me if I was in fact the lawyer. So instead of the lawyer obviously testifying, I can do that for the lawyer for the client and be able to detail that. And I can go through and determine with that client, what witnesses would you call, for example, in this case? And in this case, it was an individual that had taken a plea to a lifetime sex offense, had violated his probation by means of being somewhere he wasn't supposed to be, in a park, and then pled guilty to that, not understanding that his probation on the lifetime sex offense was going to land him in prison the rest of his life. And I asked him questions about how the probation violation interplayed with the life sentence. He had no idea what a life sentence was. He had no idea what the probation officer might say. He had no idea when I asked him, well, what if the probation officer got on the stand And the probation officer said, yeah, he's been at the park every single day. And you know that's not true, right? You've not been to the park every single day of your life, right? What would you do? I don't know, I just sit there. I just sit there. Well, your client's not able to assist you if your client's just sitting there. If your client's nudging you saying, no, it's not true, I haven't been there every day. I was only there that one day, and this is what I was doing that one day. That is what the expert, without even using a legal expert, which is a good idea to do if you can get the funds for it. In Colorado, they're able to get the funds to have a legal expert. It's worked in these cases. But if you can't, you go after that expert on the very, very, very same principle. You ask that expert, well, did you ask him what witnesses were called? Did you ask him what would happen if testimony came out that was absolutely false? Did you ask him what he would do in that case? I'm checking my timer because I go too long, but I'm feeling like I'm doing good. Okay, so I got in this whole. I was really troubled for a while over these competency exams because it would just be an interview of our clients. So it would be like this, 20-minute bullshit interview of our clients, right? And I didn't understand why there's all these forensic tools that are available to psychologists, and they weren't using them in addition to doing an interview. And I was really critical of it in the beginning. Now, you'll look in that article that I provided you, there's a lot of discussion about whether or not a tool should be used or not. An assessment tool, like there's an ESTR, you might have heard of the MacArthur test, the FIT test. There's certain tests that they'll give your client where they'll put like a vignette of a case, and they'll ask your clients, what they would do in these certain situations, and then that test determines whether or not they're competent or not, or it helps them achieve an opinion on whether or not they're competent or not. And not all psychologists use tests. A lot of them don't because it takes too much time, and they'd rather just do an interview. The thinking behind this is really the interview is the best. This is the best tool. As long as the doctor is looking at records, has looked at the history of your client, has reviewed the history of your client, has talked to you, counsel, about the difficulties that you're having in consulting with your client and your client understanding what's involved in the case. And then the added hitch would be after your interview and you're finding out whether or not at that moment your client is incompetent, whether or not that doctor takes the extra step and uses one of these tools, these exams. These are like these exam tests that they give them. So do they do that or not? Some cases they do, sometimes they don't. When it comes to somebody with a cognitive impairment, it's almost necessary. When it comes to somebody that's psychotic, not so much. And you all know, too, that the primary reasons why somebody is going to be incompetent or pure incompetent is because either they have a cognitive impairment or because they're psychotic. Usually those are the two, disabilities, mental disabilities that somebody would have that would cause you to raise competency. Well, if they didn't use a tool, you go after them, right? So you say, well, you didn't use a tool, and if you had used the tool, it would have avoided your personal bias in this case because you would have had some kind of objective exam that you could have given the individual. And why didn't you get as many sources of data as you possibly could have? Like, why did you just stop at just looking at the interview? Just doing an interview. If in fact sometimes they don't even look at the client's historical records, which they need to. Obviously, you go after them for that. And so if they didn't use a tool, you go after them. If they did use a tool, go after them. So if they use a tool, it's imperative to look at what those tools they used were. And the article that I gave you goes through and critiques those tests and exams, whether or not it's relevant for your client's disability, whether or not those tests have been found to be verifiable, whether or not those tests have been found to result in findings that are reliable for a judge to rely on or a doctor to rely on in terms of the finding. So if I did a whole lecture on the tools, these tests, we'd be here for another hour. But the best advice I can give you right now is that they don't use them that much, but they use them in high-profile cases or in death penalty cases. And when you see them use them, you attack that tool that they're using. You go after it, because a lot of the time, the manuals say either yes or no, you shouldn't be using it on this type of individual. And you have to be careful, because not one tool actually looks at all the criteria you need to attack when it comes to the Dusky standard. So one of the tools that they use often is an IQ test, right? So that is sometimes they use that in these cases where they are very heavy circumstances, sex offense cases where someone is developmentally disabled or they have a cognitive impairment. And the person might have had like 2 or 3 IQ tests by the time maybe the last evaluator gets to them. So something that's not hard to attack and doesn't take a lot of time, but if you know your client has had previous IQ scores, it's important to study and understand the Flynn effect. So the Flynn effect is the failure of an expert to adjust the score based on the repetitive nature of the testing, because you go up 3 percentage points every time you take an IQ test, because you obviously start learning what the questions are. And that is something that a lot of experts don't take into account. And that has been studied. The guide here that's on the bottom, that citation, takes you right to that, and you can cross-examine an expert about that if they haven't taken that Flynn effect into account. So I provided you, the very last document I provided you was the Colorado State Hospital's competency workbook. It's sickening. So in Colorado, they give this workbook to the patients that arrive there. And if they memorize these acronyms, they have determined that they're competent, right? So I have rote memory. I can tell you what IPASS-A is, and I've looked at this so many times, I still don't even know what it is. But it's like I is something. Yeah, I'm telling you. And you're not the only one that needs glasses, by the way. Innocent until proven guilty, and the P is prosecutor to prove his case, A is attorney, S is silence, another S is speedy trial, and A is appeal. What the hell does that have to do with the person that's charged with murder? I mean, if someone says the prosecutor's to prove his case, what the fuck? I mean, and how? How are they going to do it? But this is what all of our clients are walking out with. So you ask for this. You say, I want to have all the materials that you provided to my client in order to make a determination that my client was competent. That would be really nice. And or your client might have this, like mine did, like kind of all folded up. It was like super tissue papery because he was like trying to memorize it so badly because he didn't understand, that, this was the way for him, basically to end up in prison the rest of his life. He didn't understand, but he's like trying to memorize these acronyms as best he could. But, you scratch the surface just beyond these acronyms and you understand that your client doesn't understand shit. And that's when you can go after those experts and say, oh yeah, you found him competent because you knew what IPASS-A was, which is even shocking that your client would even remember that. And does that assessing professional really know what would go into the defense of the case? And that's that Duhan case that discusses that. Does that professional really understand? Usually they don't. Usually they have no idea. They're coming in there, they're determining what kind of psychotic delusions your client has, And then they're pretty much determining that it's relevant that they have delusions and it's not relatable to the case, and then they find your client competent. But this case is explicit, and it says that the assessing professional actually has to know what goes into the defense of the case, and your client must understand that, and your client must know it, and your client must be able to cite to it with relevance. It's crucial. So in these tests, these measures, when you're challenging the results, whether it's the Flynn, it's an IQ test, whether it's one of these tools that are used, whether it's these acronyms, these workbooks, sometimes what ends up happening is your doctor doesn't understand that you know that you've come to this training and that these tools can't actually make a determination of competency or incompetency. That's incorrect, that's false, that's unethical. The tools guide an expert to be able to make an opinion based on the realm of everything that they've reviewed. But a tool itself, an exam itself, a IQ test itself does not provide an expert to be able to say, well, this test shows and says that they're incompetent or says that they're competent. That's not what the test can do, because these tests, these measures don't take into account the causes of low scores, and they don't indicate how much impairment is enough to justify incompetence. So there's no levels in these tools. There's no levels to be able to make that determination. So don't allow that to happen. Don't allow an expert to be able to make an opinion and say, well, I'm using a tool. I just used a test. You challenge that. So it's strange. In the Dusky case, it doesn't say that tie in that if you're incapable of understanding or appreciating the charges or consulting with your lawyer to a reasonable degree, that it has to be as a result of having a disability. That's nowhere in the case. But we all know that's been integrated in our statutes, in federal law and state law, that you must have a mental or developmental disability that impairs you to be incompetent. And something that doctors do is they just kind of copy a diagnosis that you might have had before, and they put it in there. Some doctors do diagnosis. It's not really super important that they diagnose. It's more important about how your client is able to communicate with you and understands and appreciates the proceedings and can make decisions. But you start getting into these fights that with your doctor, because your doctor will say, for example, well, their IQ is a 71. So they don't meet the definition of developmental disability. They're not impaired developmentally because they don't meet this definition. They're not schizophrenic. Well, there's some diagnoses that actually are new in the DSM-5. It's not so new anymore. It's 5 years old. But there are some diagnoses that can affect your client's ability to understand and the capacity and comprehension of a case and to be able to work with you outside of maybe what we're normally used to. I think we're seeing a lot of people who are suffering from PTSD. And if your client might have PTSD, but look at this new definition. It expands the stressors to include a trauma that happened to your friend or a family member. So your client might have PTSD, and it might impair your client's ability to be able to understand what's going on because they're so stressed out by what's happening to them that their PTSD is coming up in the case. And it eliminates the element and the requirement that a person reacts to trauma with fear, helplessness, or horror, that there has to be some reaction. Your client can still have PTSD. Your client can still be impaired without having to show that. This also, the DSM-5 added a specific learning disorder. later on in this presentation, I'm going to show you a client of mine that was found to be competent because he, at that time, the law hadn't changed, the Hall case hadn't been ruled on, and he had like a 71 IQ, and he wasn't officially developmentally disabled by the old DSM. And the DSM, and so the doctor said, yeah, he doesn't understand all this stuff, but he doesn't have a disability. Sorry, so yeah, I'm going to find him competent. And the judge is like, check that box, great. But this learning disorder would qualify because it's a DSM, and it actually has nothing to do with your IQ, your client's IQ. It talks about your client's learning disabilities, your academic skills being way below average, persistent difficulties in learning keystone academic skills during onset years. And this disability actually, you don't have to be so focused anymore about having to meet the intellectual disability definition anymore, because if your client has a significant learning disability, you need to talk to the doctor and say, look, maybe your client wasn't diagnosed with this before because this is a new diagnosis the Psychiatric Association has built into the DSM-5. I want you to take a look at it. I feel that my client meets that, and that disability qualifies, and that's why my client is incompetent. And then, of course, the intellectual disability definition changed. With the Hall case, the argument was over whether or not, prosecutors, they wanted to put Mr. Hall to death. And his IQ was wavering around 70, 71, or 69. And finally was, there was a ruling that he'd be put to death because it was a 71. And the case went to the United States Supreme Court, and they said, nah, you know what, we've heard enough from the Psychiatric Association. There's no more of this. We're done with this baseline of 70 IQ. It's done. It's out the window. We're throwing it. And so now what's imperative actually now is more about the adaptive functioning, what your client can do, what your client's able, can they live on their own? Can they pay their own bills? Can they get ready on their own? And so it strips away what so many of us have fought for in front of judges and prosecutors, arguing that your client does have a legitimate intellectual disability because your client's IQ might be a 75. And it kind of gives a variance of up and down 5 percentage points. So it goes up to 75. So no more does it have to deal with that IQ. So you can use that if you get in that fight with your expert. So there are many materials that are useful in being able to attack an expert and look at I think the definitive criteria to get on a cross-examination. Of these books, one on the bottom, I didn't bring it with me, but the one on the bottom that's got that yellow strip on it, it's the Patricia Zaff book. And it's the evaluation of competence to stand trial. It's a little thin book. It's like this. And it's about $15, maybe more, $20 on Amazon. Every office should have that book. That book will go through what an evaluation should have in it, and if it doesn't have in it, how you can attack it. And it is an authoritative book. It is almost like a treatise that every single doctor that is doing an evaluation of your clients should understand and should be able to answer questions that you glean and you get from this manual. The other books that are there, those are some of the most high-profile psychologists, Grisso, Melton, that have written about competency that I cite in a lot of these slides. So you don't need to get the book, but I'm just showing you can get the book and hold it up in court. But the quotations from the court, from these books are inside of these slides that talk about your client's ability to make decisions. I think the easiest tool to use in cross-examining an expert is this article. It's the attachment to this article. So Jennifer Scheme and Stephen Golding are incredible psychologists, and they did this meta-analysis of competency and evaluations and how to attack doctors. And I put that in your materials. So in your materials is the whole table. This is just a photograph of a little part of it. And it's not very long. It's about 2 pages. And it breaks down. This is it. It's very, very short. You can get the whole article, but you don't need the article. You just need these 2 pages. That's it. And it breaks down exactly what you need to ask the expert when they're on the stand. That's it. This is a chapter, a sentence. So there's 4 capacities that are identified that you have here. I think there's more. There might be 5 capacities. So capacity to comprehend and appreciate the charges or allegations, the capacity to disclose to counsel pertinent facts, events, and state of mind, to comprehend and appreciate the range of potential penalties, basic knowledge of legal strategy, engage in reason choice, and it goes on and just lists what the capacities are. Then it gives you the subdomains of each of those capacities. So you don't even need to read any of the books I just gave you. Just take this list and draft your questions. It's so easy. So you go, okay, did you ask my client about whether or not he has factual knowledge of the charges? Was he able to report the charge? B, understanding of the behaviors to which the charges refer. Did you ask my client about that? Comprehension of the police version of events. Did you ask him about that? What did he say? You just take these, and you can see in mine, you'll see all my check marks because I use it every single time I do a cross-examination of a competency expert in order to be able to highlight for the judge the fact that the expert did absolutely nothing to make a determination that my client's not able to assist me and can't make decisions and does not have adjudicative competence. So one of the most revealing and new areas of competence is congruence. That's something that no one really used to talk about a decade ago, but now it's become commonplace. You must use it in your advantage when you have a client that's charged with a serious crime. So the most infamous psychologists, Melton, Kaplan, Grisso, have discussed it in all of their books, but it's not really used in the courtroom, and it's pretty much ignored by judges, and we need to make it relevant. And what this means is this, that your client should have a level of capacity to understand simple charges. They may, but it might be grossly inefficient when more complicated offense is involved. So your client might be perfectly competent when it comes to, a misdemeanor criminal mischief case. Might be perfectly fine, can understand that throwing the phone on the ground broke the phone, that's the crime. Your client might understand that. But, for example, when it comes to your client, like mine that you're going to see in a minute, that was charged with burglarizing a second-story home in the middle of the night and accused of sexually assaulting an 8-year-old girl and then jumping out of the house and then 2 weeks later being arrested for this crime, you need a much higher level of cognition and understanding of what it takes to be able to prove that case, of what elements are involved in a burglary and a sex assault, what the defenses might be to that kind of case. And the examiner, your doctor, must be able to present the logic in the report that links their observations that your client is specifically able to comprehend and understand. They must be able to put that inside the report. And if they can't, you question them about it. What did you do? What is your logic that links this serious proceeding that our client is facing with what you've done to ensure that the client understands this high level of a case and the seriousness that's involved and all the witnesses that are going to come in? That is now used more commonly, but doctors still don't pay attention to it. They're like, no, whatever, he's not, it doesn't really matter. Well, it does matter. It does matter if your client's able to be cognitive in a case, and that it kind of hurts you when it comes to cases that are not as serious, but then you're probably not challenging competency as vociferously as you would be. So this is Tyler Sanchez, who, this is something that, because Tyler Sanchez is so nonverbal, I was really nervous that the doctor wouldn't report the exam correctly. That there's so many nonverbal cues that my client had. He was so learning disabled, and his processing was so slow, and he had no verbal processing skills, that the doctor would bypass everything that happened in the examination and just write that the client was competent and use whatever, wouldn't highlight how long it took to answer the questions. And this case was a false confession case where Tyler was interrogated for about 36 hours, almost straight, and he kept saying, no, I didn't break into the house. No, he didn't ever use the word sexual assault. He didn't understand what that was. He was 19 years old. He turned 19 the day he was interrogated. Never had been in jail before, never had been in any trouble before, and was like whisked away as he was driving home from his job at McDonald's, because they thought that there was a rash of burglaries in this neighborhood, and whoever it was that was out at this time of night where there was a call made that there was a potential burglary, that whoever was driving around that potential burglary was the person who committed the sex assault. And Tyler happened to be driving through that intersection nearby where that alleged attempted burglary had happened 2 weeks later. So Tyler gets pulled over. He gets interrogated for a series of hours. He's denying. And at the very end, after he'd been filled with every single fact of the case, and a polygraph ensued, he wrote an 11-sentence confession, of which 2 sentences were relevant to the crime. And he was charged with this burglary and sex assault. He was clearly incompetent. He wasn't able to waive Miranda. And I challenged, obviously, the case in many, many areas, but I didn't want this competency exam not to be videotaped, because I was so concerned that after watching parts of the interrogation were videotaped, I knew, and working with him, that he wouldn't be able to verbalize really what was going on in his head, and the doctor then would not be able to properly document it. So I asked that it be videotaped, and I was granted that request because, of course, when would the prosecution ever not want to have a videotape of your client, especially in a competency exam? But it was important in this case, and I knew my client well enough where I knew it was okay to do it, and it wouldn't harm the case. And so this is a snip from the competency exam. And I think when they initially did this video, they put my client in the wrong position. You're going to see they put the doctor in they had not done this before. They messed up, but you'll see my client there.
They sent you to Douglas County
Justice Center.
Okay. All right. And what are the charges against you?
This is 1.5 years after the arrest.
Do you remember how many charges there are?
No.
What is a charge? When I use that word, and Go ahead. What is the charge?
When they pull something up against you, or
Say more about pull something up against. What do you mean by that?
like they charge you with something. Can't really put it in words.
Use the word charge in a sentence for me.
This is what you're gonna be charged with.
Okay, and if someone said that to you, what would that mean?
I don't know.
What did the police say that you did?
That I trespassed, or I don't remember exactly.
Anything else that you remember in terms of what the police say that you did?
So that was a year and a half after the arrest, and also about 20 court appearances that we had had before that. And you can imagine, like you would be, I was fighting like fucking crazy in there and talking about these charges and the case and how wrong it was, how fraudulent these charges was, and it's malicious, and he still didn't understand. And then this is the cross that came from that. And I use this. It's almost as if you could read this little chart. And I said, we left off talking about competency in Mr. Sanchez's comprehend and appreciate the charges or allegations. And the first thing we talked about was whether or not Mr. Sanchez has a factual knowledge of the charges. Isn't it true at the time when you asked Tyler what the charges were against him, or having him attempt to label those charges, at that time during the interview, he did not know what, he wasn't able to identify those to you. Isn't that true? Initially in that clip, that was true. So he's got the to ensure he's got the capacity to appreciate the allegations, part of that is remembering, being able to remember the events surrounding the arrest. And he wasn't able to give you anything throughout the entire interview, not just the first hour. He wasn't able to describe to you the events surrounding his arrest. Isn't that right? Yes, he did not do that. One of the other components of being able to comprehend or appreciate the charges or allegations is understanding the behaviors in which the charges are. Is that right? Yes. Did Mr. Sanchez ever indicate to you that he knew what sexual inappropriate touching would be? He did not indicate that to me. So he never defined what a sexual assault was, did he? Not beyond what he said and what's on the video. He never used the word. He didn't know what the word sexual assault was, and this was actually from, and you remember reviewing those and reading that Detective Mikes had to define what a sexual assault and sexual inappropriate behavior was. Do you remember that? Yes. He didn't know what it was. Is that correct? That's what he said. That's what he said. Yes? Detective Dixon also had to define to him. Yes, I believe so. And the term they kept using was sexual inappropriate, right? I believe that's the term that they used. The term didn't come from Mr. Sanchez, right? And the material reviewed, I think they were used by others before Mr. Sanchez. So I just took, it was nothing fancy, but I just took exactly what's in this chart on whether or not someone's competent. Do they understand what the charges are? And was able to cross-examine the doctor.
What is a right?
Example, you have the right to remain silent or
And in that example, you have the right to remain silent. What does that mean, the right to remain silent? What is a right?
you have the right to either talk or not talk at all.
Okay. All right. What would it mean then to waive a right?
Right. I don't know.
Pretty fundamental, you know, when it comes to whether or not your client's going to make decisions to testify or not testify, whether or not your client waived Miranda or not, if they understand what waiving a right is. I mean, it's amazing. He was found competent. Remember, he was found competent. So I understand, yes. Let me finish. I'm almost done. Hold your question. There's one more clip after this. So I understand that what happens in the courtroom. I get it. Like, you can have all these awesome tools and all the guidance that we're all giving you, and you already have yourselves, and the judges are still like, no, fuck you. I know what your client was charged with, and your client wrote a confession, and your client's fucking guilty, and I'm going to make this trial go forward, and I don't give a shit if he doesn't know what it means not to waive a right. And so this was the cross-examination. He might have to take or give up rights if he decides to testify. Is that true? He should be able to understand all of that. Yes. And he has a limited and incomplete understanding of the word right. Is that true, as indicated in this clip? Yes. The same, he doesn't know what it means to waive a right. If he knew what the right was, if he understood what a right meant, is that true? At that time, I think he did not know, or certainly didn't indicate to me what it meant to waive a right. Yeah, no shit. So now this is, so the defense in this case, you know, is false confession, obviously, and also we don't know really what happened with this girl, but it just seemed really strange that her father was in the bedroom, you know, and was taking a shower like right after she screamed. It's like all really bizarre. And then on her panties, there were two different DNA profiles, dad, and then some unknown male, not Tyler. And so, you know, the defense was, it wasn't me, it was somebody else, and alternate suspect, and then I falsely confessed. Pretty simple for someone who, you know, might be able to comprehend such a charge.
Ideas on how to defend against the charge, how to defend yourself.
What do you mean by
Well, ideas on how you could convince the judge that you're not guilty.
yeah?
What are your ideas? Tell me.
It's my attorney's job that
No, it's not.
Say more. Your attorney's job to what?
to, as I said, defend me on my behalf.
Okay.
And then here was the cross. And it is true that being able to understand the capacity to comprehend and appreciate the range of possible penalties that could be imposed. Hold on a minute, let's go to that. Another component of that is whether or not Mr. Sanchez can assist me. And that's a pretty, and knows what that means. Isn't that true? Mr. Sanchez indicating to you that he wouldn't know how to help me defend him. Isn't that accurate? Yeah, I think not. We've been in court litigating it for almost 2 years, and we've been litigating a lot of things, but most of all, some of his defenses, which are false confession and alternate suspect. And he didn't mention either of those to you, did he? He did not. That would have been an appropriate answer to that question, wouldn't it have been? A relevant answer? Yes, in this case, yes. He would have said, I didn't do it. Or he would have said, I felt coerced into saying what I did. Those are some of the things he would have said, for example, or somebody else must have done it. Yeah, he could have said those things. And his response to you instead was, it's her job to defend me. It was almost a circular answer to your question. Isn't that fair? Yes, I think he sees it as he would rely on you to be knowledgeable about the defenses. He didn't provide to you any indication that he has the capacity to engage in a reasoned choice about what defense to take or what I should do or not do in court. Isn't that fair? I think that's probably fair to say in those clips. That's fair to say in those clips. That's, I think, how you put, and I know I'm highlighting, I'm able to use a videotape, so it's easier, right, for me to be able to do that. But even stripping away any kind of video that you don't have from a competency examination, it doesn't take away that you have this really simple guideline to be able to attack an expert on whether your client can help you, can make reasoned choices, can make decisions, and is able to really cooperate and understand what's going in the trial, instead of an individual that many of us represent that are found competent, that absolutely have no idea what their rights even are and what a right even is. Fortunately, Mr. Sanchez, I had a mental impairment condition exam on him. In Colorado, there's a strange law, and the forensic psychologist that was appointed to do this exam determined that he was incompetent and that he falsely confessed. And the DA was forced to dismiss the case after 3 years. And Mr. Sanchez's civil case, he has filed against the sheriffs who interrogated him and had him falsely confess and jailed and suffered through this, are going to be going to trial in 2 weeks. So hopefully that turns out for him.